public interest litigation through the lens of one case, the challenge to stop the 1985 All Blacks tour of South Africa. As we noted in the last episode, cases which advance social or political issues via the courts are rare in New Zealand. Even when they are brought, they are often unsuccessful. Instead, we like to think of the roles of politicians and judges as being completely separate. In New Zealand, our constitution is based on the idea of separation of powers. Part of this idea is that Parliament and the courts each have a separate role. The role of Parliament is to make laws, and the role of courts is to apply those laws. But in some cases, the line which divides those two functions can be very fine. Cases which explore the boundary between law and politics are sometimes called public interest litigation. Public interest litigation has three features. First, it involves plaintiffs who represent a social or political group rather than a single individual. Secondly, public interest litigation involves matters of widespread social, political, or economic importance. Finally, public interest litigation often takes place where the plaintiff believes that their issue cannot be, or is not being, addressed by Parliament or other branches of government. They believe that the courts are the best or only way to achieve their aims. In the last episode of For the Good of the Game, we started to explore the background of one of those cases, the legal battle against the 1985 All Blacks tour of South Africa. In this episode, we will look at how the court case started to come together. In particular, we will look at two important ingredients needed to bring a case to court. The first is a legal argument. The second is finding a plaintiff with standing, meaning someone who has a right to sue. Both these tasks would prove difficult for the lawyers who were bringing the case. On the 17th of April 1985, the New Zealand Rugby Union announced that it would accept the invitation of the South African Rugby Union to send an All Blacks team to South Africa. The announcement came after government pressure, including a unanimous resolution of Parliament, urging the Rugby Union not to accept the invitation. The government was concerned that the tour would be seen as an endorsement of apartheid and jeopardise New Zealand's international standing, particularly in Africa. But the government would not take the drastic step of confiscating passports to stop the tour. The Rugby Union, however, was adamant that the decision was the right one. Despite condemnation from the New Zealand government and black South African leaders, Rugby Union chairman Cesc Blasey told media that he had considered all the relevant factors, but at the end of the day, sports and politics were not meant to mix.
Whatever anybody else may say, I can just repeat again, as I've said many times, it is not an endorsement of apartheid.
Well, how evil does a regime have to be before you say we will not send a team to that country?
At the present time, we are dealing with a rugby matter, and if you wish me to get into a discussion about any political situation in a place like South Africa or anywhere else, I don't intend to do it.
Another rugby matter, of course, is the interest of the game in this country, and you say that that guided you in your decision yesterday. Already we've learned that the Australia-New Zealand test in Auckland later this year is now under threat because of this decision. And of course there are the unknown effects that will result from outrage in this country by people who otherwise would be ardent rugby supporters. Have you really acted in the best interest of the game, do you think?
Well, the decision of the council was made having all those sorts of factors into account. We don't accept at the present time that the situation is going to be quite like that.
Preparations for the tour went on unabated. But at the same time, preparations were also being made to stop or disrupt the tour as much as possible. Anti-tour protest groups, such as HEART, were planning mass demonstrations, and the police were bracing themselves for protests on the same level as 1985. Meanwhile, another, less likely group was also meeting: lawyers. In Auckland, a group of 30 lawyers met at the local Law Society's headquarters. The meeting was chaired by Edmund Thomas QC, known better as Ted. We heard from Ted Thomas in the previous episode. In 1981, he had marched in opposition to the Springbok tour of New Zealand. This time, he had a different plan of action in mind. The meeting on the 1st of May decided to fight the tour on several fronts. One group of lawyers would promote economic boycotts of South African goods. Another would draft legislation that would make the Rugby Union pay for the increased policing costs caused by the tour. Others would lobby rugby sponsors to withdraw their money. Similar meetings were held in other cities, and working groups of lawyers were formed across the country. The final working group formed at the meeting was given the job of looking for ways to challenge the Rugby Union's decision in court. Ted Thomas himself took on the leadership of that group. He recruited John Marshall, a leading member of the Wellington Working Group, and Sean Elias, another Auckland barrister, to assist him as his two junior counsel. Rodney Hanson, a partner at a large Auckland commercial law firm, agreed to be the solicitor for the team. The challenge for Ted Thomas and his team was to find a legal reason why the tour should not be able to go ahead. They had to prove that the rugby union had breached some rule that would make its decision invalid. They were up against it. The last time lawyers had tried to stop an All Black team from travelling to South Africa, in 1970, they had failed. Ted Thomas started by looking at the rugby union's constitution. The constitution of an incorporated society, such as the rugby union, sets out all the rules that the society has established for itself. Like all incorporated societies, if the rugby union had acted outside the scope of its own rules, the High Court could intervene by issuing an injunction, or order, requiring the rugby union not to go through with its decision. The rugby union's constitution set out a process for making decisions. Some decisions could be made by the Rugby Union Council, while others could only be made at an annual general meeting of the representatives of all the provincial New Zealand unions. The rules also said that certain decisions could be challenged by taking them to the Rugby Union's own appeal council. When drafting the Statement of Claim, the document that sets out the grounds on which a court case will be brought, Ted Thomas drafted up two very technical points, arguing that the tour could only be made at the annual general meeting, and that the Rugby Union had failed to appoint an appeal council. By Ted Thomas's own admission, this was a very weak draft Statement of Claim. But then Ted received a phone call from the solicitor, Rodney Hanson, who had also been looking at the Rugby Union Constitution. He had noticed something which Ted hadn't.
And I received a call one day, a telephone call at my office from Rod Hanson, who'd also been working on these two technical points. He had read the Rugby Union's Constitution, read out the provision that they have to act in accordance with the best interests of rugby in New Zealand. And he said we could allege that they'd failed to do that. At that time, I thought the ground was hopelessly weak, real kite-flying stuff, but it was included in the Statement of Claim.
The basis of this third ground in the Statement of Claim was that the Rugby Union's Constitution required it to promote, foster and develop the game of rugby in New Zealand. The lawyers were arguing that in making its decision, the Rugby Union had failed to do this. Instead, by touring South Africa, the Rugby Union had made a decision that would be bad for the game of rugby. As we heard from the interview with Cess Blasey earlier, there had been some discussion about whether the tour of South Africa was good for rugby or not. There were many current and former players, including Chris Laidlaw, who we heard from last episode, who believed that sporting contacts with South Africa and the 1981 tour had harmed the moral standing and popularity of New Zealand rugby. Rugby coaches and school teachers, such as Murray Deaker, the deputy principal of Takapuna Grammar, believed that school children were being put off rugby. In Parliament, the Deputy Prime Minister Geoffrey Palmer had argued that the Rugby Union was possibly acting contrary to the interests of rugby, and the Heart leader, Kevin Haig, had also suggested that the Union was in breach of its constitution. Phil Gifford, a sports journalist who had covered the 1981 tour and a passionate rugby fan, agreed that the tour would have given rugby a bad image.
I agree 100% with them. It would have been damaging to rugby. The other thing that would have happened, I think, if they toured in 85, I'll guarantee this would have happened. Images of 81 would have been back on television again, because it was only 4 years before, and there would have been protest marches, and the anti-tour organisation would have been much better organised. And I know they wouldn't have had a Springbok team, but they would have, if I'd been them, I don't know how they would have gone, but one tactic, I guess, would have been to picket games here in New Zealand, maybe picket the Rugby Union headquarters and so on. So first of all, I think you would have revived the whole festering mess of the 81 tour. And then the other thing too that I think you would have run a huge risk of is if there'd been something really appalling like the Sharpeville massacre had happened while they were over there.
The process that led to the development of this argument is typical of many cases. The lawyers who wanted to bring the case against the rugby union were mainly rugby fans, but the interests of rugby in New Zealand was never their primary motivation. For Ted Thomas and Rodney Hanson, the tour was about the moral issue of endorsing apartheid. Often when we think of a court case, we think of the starting point as being the rules or the area of law that someone has breached, and then think of an outcome that would address that. In reality, what often happens is that a client first identifies the outcome they would like from the court case. Then the lawyer identifies the best legal argument that will help them achieve that outcome. It just so happened that in this case, the best way to achieve the outcome of stopping the tour was to show that it was not in the interests of rugby in New Zealand. The legal points were developed only after the political or moral aims had been identified. Even though the interests of rugby weren't the main motivation behind the case, this line of argument offered them their best chance of winning. The argument developed by Rodney Hanson became known as the against the objects argument, because it centred on the tour being against the objectives of the rugby union as set out in its constitution. But the lawyers were still left in a very unusual position. They had a case, but they were not able to bring the case to court. In general, a person can only sue if she or he has standing. For example, if they have an interest at stake, or if they have been affected by a particular decision. The lawyers trying to stop the tour were concerned citizens, but they did not have any interest in the rugby union's decision. If their case was going to succeed, it needed to be brought by someone who did. This situation was unusual, because most cases work the other way round. A person is affected by something that happens, and they then look for a lawyer who can represent them. In this case, it happened back to front. The lawyers wanted to stop the tour. They then created a legal strategy, but had to find someone who could bring the case. The lawyers started looking around for a plaintiff who had standing. They started by looking at the organisations that were closest to the New Zealand Rugby Union, the provincial unions. The constitution of the New Zealand Rugby Union said that its members were the 27 affiliated unions across the country, from Northland to Southland. The lawyers thought that if they could persuade one of those unions to bring the case, they would have standing. One of those unions was North Harbour, which covers the northern and western parts of the Auckland area. This area had been particularly affected by the 1981 tour. In protest at the tour, rugby players, schools and sponsors had withdrawn from rugby. The North Harbour Union had consequently opposed the New Zealand Union's decision to tour South Africa in 1985. According to Phil Gifford, who lived on the North Shore, even at the time of the 1987 World Cup, people were still angry about what happened in 1981.
Brian Hall, the coach of the 87 team, has told me on a couple of occasions about how, so it's 1987, like it's 6 years after the 81 tour, and the All Blacks were at the Paonama Hotel, over in sort of Takapuna, North Cape, and he noticed that when they went into the city, they wouldn't wear their All Black uniform, anything that tall said All Blacks. And he talked with them, and they said, well, when we go in, there are people in the street that abuse us and call us racist and that sort of thing. And so that was happening like 6 years after the 81 tour.
The North Harbour Union seemed a good candidate for an organisation with standing to bring the case. Ted Thomas explains the lawyer's approach.
A statement of claim rested on the left-hand corner of my desk for over 2 weeks while we tried to find plaintiffs. Obviously, we wanted the plaintiffs who were involved in rugby at the highest level because we knew we would face a standing challenge. We tried initially for a rugby union. There was only one union that was possible. That was North Harbour. North Harbour, through its treasurer, he rang me initially and said that they were interested in supporting the proceedings. The North Harbour Union had a vital interest in this tour stopping. They were in a financially precarious position. And if there were disruption and protest, their sponsors would withdraw their sponsorship and they faced insolvency.
Although the North Harbour Union was sympathetic to the lawyers and said they would help, they weren't prepared to bring the case themselves. The lawyers couldn't think of any other provincial union who might be willing to bring the case. So they started looking one level lower in the rugby hierarchy. Each provincial union had several rugby clubs that were affiliated with them. But no rugby club was willing to take the case either. The lawyers knew that the lower down a plaintiff was in the New Zealand rugby hierarchy, the less chance that the court would recognise their standing. But they had no chance but to go one step lower. Not a provincial union, not a club, but an individual who was a member of a rugby club. And they were getting anxious. It was now mid-May, and the tour was due to commence only 2 months later. For a complex case, 2 months is not a very long time to conduct proceedings. But then they had a breakthrough. A lawyer friend of Sean Elias, Greg McGee, was a successful rugby player who had at one time played for the junior All Blacks. He had protested in 1981, going so far as burning his junior All Blacks jersey outside Eden Park. He had also written a play called Foreskin's Lament, which was influential in the anti-tour movement. He seemed like a good candidate for a plaintiff, but he hadn't been a member of a rugby club for 10 years. He did have a friend, however, who was. Greg McGee's friend was another Auckland lawyer, Paddy Finnegan. Paddy had played rugby at Otago University and had joined the protests in 1981. Most importantly, from the lawyer's point of view, he was a paid-up member of the Auckland University Rugby Club, where he coached a team. I asked Paddy about how he came to be plaintiff.
I received a call from Ted Thomas, and he just sort of basically said, was I prepared to be a plaintiff? I said to him, can you give me 24 hours to think about it? And my reasons were, well, I immediately realised that I was going to get flung into the public arena. What I did was I communicated with a colleague friend, Professor Michael Taggart, and I asked him if he could give me an opinion to see whether or not, was I going to be wasting my time?
Professor Michael Taggart was one of New Zealand's leading experts on constitutional law.
He gave me an opinion overnight, and basically it was, yes, you've got standing, he said, but you could struggle on the substantive issue. Then when I got the opinion, Ted rang me, or I rang Ted, and I said, yes, I'm prepared to be a plaintiff. Because I thought more from the standing point of view that, well, I had the right to bring the challenge. Whether we're going to win or fail, is really for the future.
And that was that. Paddy Finnegan didn't think they would win the case, but he was confident that the court would at least recognise his standing and hear it. That was enough for him to agree to become the plaintiff. But the lawyers wanted to be doubly sure. They were worried that if they had only one plaintiff, they could be open to a challenge against standing, and the whole case could fall over at an early stage. As insurance, the lawyers began searching for a second plaintiff. They found another lawyer who was a member of a rugby club, Phil Ricordan. Phil had been a successful rugby player and had spent several years playing overseas in France. On his return, he had helped represent some of the protesters from the 1981 tour and had been involved in a movement of lawyers opposed to nuclear testing in the Pacific. He had no hesitation in becoming the second plaintiff. The lawyers now had a case and two plaintiffs. They were ready to go to court. Their claim was filed on the 20th of May 1985, only 2 months before the All Blacks were due to depart for South Africa. The claim asked the court for two things. First, that it issue a declaration that the decision to tour South Africa was unlawful and not made in accordance with the constitution of the rugby union. Secondly, the plaintiffs asked for an injunction, an order that would restrain the rugby union from implementing its decision to tour South Africa or proceeding with arrangements for the tour. The declaration and the order were sought against the rugby union and also the 15 members of the Rugby Union Council who had made the decision. In law, cases are named after the first plaintiff and the first defendant listed in the court documents. So the case to stop the 1985 tour of South Africa is known as Finnegan and New Zealand Rugby Football Union, or simply Finnegan for short. Unfortunately for Phil Ricordan, his name isn't included in official references to the case. As we mentioned earlier, the way that the plaintiffs came together in the Finnegan case was highly unusual. I asked Ted Thomas whether he had ever before had a case without having any plaintiffs.
Oh, no, that would be very unusual. I mean, this case was a case without a plaintiff initially, simply because it was initiated by the lawyers. In all other cases, the client walks through the door.
Although this back-to-front process is unusual in most cases, it is more common in public interest litigation. A political pressure group or their lawyers will identify the issue that they want to change. At the second stage, they then search for a legal argument that will help them do that. Thirdly, if they do not have legal standing themselves, they will look for someone that does to take the case to court. This three-step process is exactly what took place in the Finnegan case. Some scholars and lawyers criticise this approach. They believe that the courts are not properly designed to decide complicated cases about politics or social policy. There are some strong arguments to support this view. One common argument is that judges are not elected. They do not represent the popular view of the people. Although no one objects to judges deciding cases between a few people, when it comes to matters that might have implications for everyone in the country, these decisions are best left to politicians in Parliament. This argument relates to the idea of separation of powers, that each branch of government has its own role. The role of Parliament is to make laws, and the role of courts is only to apply them. Some people argue that when it comes to public interest litigation, courts are inevitably placed in a position where they have to make laws of their own and take over the role of Parliament. Of course, in the Finnegan case, Parliament had tried unsuccessfully to stop the tour, so the plaintiffs felt that the courts were the only body that could. But there are many people who feel uncomfortable about decisions of national importance being made by unelected judges. We'll discuss these issues more in the final episode of this podcast, but it's important to think critically about public interest litigation throughout the series. What is the role of the courts? What decisions should they be allowed to make? And is it fair on the Rugby Union Council that their decision could be publicly challenged? Before we end, it's important to remember what the case was really all about in the first place: the apartheid regime in South Africa. When we think about the role of law in promoting social change, the 21st of March 1985 provides a powerful reminder that it cuts both ways. On the day after the Finnegan proceedings were filed, another trial was starting in South Africa, a treason trial of 22 activists, primarily from the United Democratic Front, a relatively moderate, multiracial, anti-apartheid political party. Just as a court was being used as a tool to mobilise protest against apartheid South Africa in New Zealand, it was being used as a tool of oppression in South Africa. The trial would last 3 years, and 5 of the activists tried would be sentenced to between 5 and 12 years imprisonment. We'll hear more about an activist from the United Democratic Front, Arnold Stofile, in later episodes in this podcast series. This podcast was made with funding from the New Zealand Law Foundation and support from the University of Auckland Faculty of Law. Archival sound recordings are courtesy of RNZ and Ngā Taonga Sound and Vision. The audio from 1985 comes from the 18 April edition of Morning Report. You can find a link to that full program on the podcast website.